to the EMS Compact bylaws. This is, the bylaws committee has worked for probably about the past year on these, working through our legal counsel, and it really is just to clean up the bylaws and make it easier to understand. We have a term in Texas they're doing with all of our bylaws now. They call it plain language. Make it so the normal person can just read it and understand what it says. So we're trying to do that here and try to improve and make it clear everyone's responsibilities and duties under the compact, which, as you know, 25 states, over 400,000 people. It was a godsend, I can say, for Texas for sure, due to COVID, and is used on a daily basis. Is it 100% where we want it? No, but we're surely getting there. And it is fantastic to see so much interest. So, Donnie, I'm going to turn it over to you as the executive director. If you want to run through the amendments that we're proposing, and then this is a small group, but please feel free to ask any questions. Either put your hand up or just butt in or whatever. And thank you for joining us today.
Yeah, thank you so much, Commissioner Speeder. I did hit the record on this session, and I think that we'll probably post this as an educational resource. So I just want to make everyone know I do plan to record this and make it available for anyone who could not join this. Just a couple more housekeeping things in addition to what Commissioner Schmieder said. This is what we call an education session. It's a public meeting or a public noticed event. There is a formal process to submit public comment. So we welcome any conversation we have today. We'll do our best to answer your questions, but just know that there is a formal process for submitting public comment that will be considered by the Commission on the November 5th date of the hearing, and that's all available on our website. With that being said, I always like to start with just giving an overview of the changes, and then we're going to go line by line and show these. And again, as Commissioner said, if you have any questions, feel free to just ask. So the compact, we have now been around about 10 years, and time flies, and we've learned a lot during that process and during that time. And there's a couple key principles with compacts that are very important. One of those is maintenance of state sovereignty, and the other is uniformity. And those are the two hinges of which all compacts thrive on. So when I talk about uniformity, under the compact, all states have agreed to certain uniform standards for licensure, and based on that uniformity, a paramedic in Texas is immediately recognized in Colorado, Virginia, or any of the 25 states. At the same time of uniformity, the EMS Compact, and I'm just going to mute some of these phone calls here. 1 second. Great. At the same time that we talk about uniformity, the EMS Compact provides an immediate privilege to practice. Under the EMS Compact, you don't apply for a compact privilege to practice. You don't buy a compact privilege. It's free and it's immediate, similar to how your driver's license is free and immediate to use in other states. However, what we learned over the past few years is that because of state sovereignty, some states view certain administrative and criminal offenses through a lens that's different from their neighboring states. And that is part of our great nation of how we work with 50 unique states with sovereignty. Let me give an example. In one state, that state may have laws on the book that says if you, for instance, have a felony conviction, then you may not be qualified for an EMS license. Another state may say, well, one felony is okay if it was 10 years ago, but 2 felonies is bad. Another state may say, well, if you have a felony in this particular category, you can never get a license. These are all core elements guaranteed under the U.S. Constitution for state sovereignty. When it comes to the EMS Compact, we identified an unintended consequence because of the immediate multi-state privilege that was granted, that in very few isolated cases, an individual was granted a license in one state that had a broader view, and then they would use that privilege to practice in another state that had a more narrow view of what the baseline should be. And it is not the intent of the compact to allow someone to practice in a state under a compact privilege, whereas if they applied for a state license, they would be denied a license. That's the high-level summary of what the Rules Committee spent a year working on. And we have a solution that is proposed in the rulemaking package in front of you. We have public notice this for 90 days. We have public comments available through our form, and there will be a hearing on November 5th. Our proposed solution is to introduce a legally sound concept of a provisional privilege to practice in cases where an individual may not meet one or more of the core elements of an unrestricted privilege to practice. And let me be very clear, a provisional privilege to practice does not mean the individual has a criminal background. It could be for any one of a number of items, including administrative reasons, educational reasons, or certainly criminal is included in that. So let me go through, and for those on the phone, I'll do my best to explain what's on the screen as we go through. So anything in red is things that have had a change to them. So in the definition section, we added a few definitions because we now are referencing terms in the administrative code, and we wanted to make sure for the purposes of the compact that we have uniform definitions. I will note that as a government entity, the EMS Compact Administrative Code will be adopted. If this is adopted, it becomes adopted as administrative code with the effect of law. And so we want to make sure we're very precise. So we added the basic definition for the term conviction, and then we added the concept of a conviction requiring review. And that is simply any conviction that a state EMS office would look at and say, we probably need to evaluate that. That's my plain English definition of that, but you can read the actual definition here. But in general, it's serious misdemeanors or felonies or crimes that would have an impact on a public protection or a public perception of safety related to practice. We did add a term for felony. We recognize that, again, under the terms of the U.S. Constitution, states can define felonies slightly different. However, because we are working across the nation, we needed a unified term for felony. And note that essentially what we say is for the purposes of the compact, a felony is anything that would be considered a felony in the state where it occurred. And so just to make sure we're clear on that. We added definition for moral turpitude. This is pretty common in state law. It's pretty common in professional licensure, and it's very common in interstate compacts. We had not defined this. We did an analysis of the other professional licensing compacts and medicine compacts, and we came up with a definition that aligns with those. And then we added the definition for this concept of provisional privilege to practice. Again, that's what I described a little bit earlier, but it's a temporary form of a compact recognition that would allow a positive endorsement from the state. And I will get into exactly more about how that works later, but we added a definition here for clarity. And then the last definition that we added was that of a serious misdemeanor. We had uniformity across the board with states that, misdemeanors have a very broad spectrum. A reckless driving could be a misdemeanor in some states, whereas, attempted, types of attempted homicide or violent assault could also be misdemeanors. but there's a very big difference in that span. So for the purposes of restricting or potentially restricting a compact privilege, we are looking at serious misdemeanors. And those are typically misdemeanors that involve a mandatory jail term, things like violence, theft, other acts that could be considered a threat to public safety or trust. So that is the type of crimes that fall into that category. So getting beyond the definitions, we moved down into the privilege to practice section, and we had a very slight modification.
Hey, Donnie,
yes,
let me
sir.
just interrupt you real quick. Before we get off of definitions, is there any questions about the definitions or what we're proposing at this time? Okay. Thank you, Donnie. Sorry about interrupting you.
Oh yeah, no, I thanks for the reminder. I'll pause after every section. Section 4 is the privilege to practice. Again, everything in black text is current administrative code. We did add under section 4.2. Section 4.2, we added the phrase or recognition alongside the phrase restoration of privilege to practice. And to explain this, we already had a process in the administrative code for the restoration of a privilege to practice. And the restoration would be is if a state, so for instance, let's say that the state of Virginia for due cause limited my privilege to practice, and they went through the process to do that. Well, this is a process where I could appeal to restore that privilege to practice, and this outlines what that mechanism is. So we're going to use the same mechanism for the recognition of a privilege to practice for someone who has a provisional privilege to practice. So we just simply added the phrase here, and so we have a unified process. It doesn't matter why your privilege to practice could be limited. We have a uniform way to restore it or recognize it. And that is all for section 4. Any questions on that? Okay, moving forward. Now we have section 4.7, and this is really the core of the changes. And so this is where we introduce this concept of a qualified license versus a non-qualified license and a provisional privilege to practice. Allow me to first summarize this in plain English, in simple terms, and then we'll look through the administrative code. We are introducing 2 key concepts here. And the first key concept is that of a qualified license. And a qualified license is a license that's issued by a compact member state that meets all of the requirements of the compact. So it's pretty straightforward. It's everything that the states have fully agreed on, and that would be a qualified license. It's also issued to an individual that does not have anything in their background, administrative, educational, or criminal, that would require additional research or consideration. So that's a fully qualified license. And to be very clear, that is the bulk of EMS providers in the United States. You know, most of our EMS providers would have a qualified license. Next is this concept of a non-qualified license. A non-qualified license is simply that. It's a license that a state issues under their constitutional authority of police powers of a state to regulate things within their state borders. A state maintains that sovereignty to do so. However, there are things a state may choose to issue a license for that are outside of what the compact was agreed to. And let me give you one simple example. The EMS Compact provides a privilege for EMTs, paramedics, and a license level between EMT and paramedic. However, there are many states who issue licenses through their Office of EMS for emergency medical responders, and some of them still call it first responders. A state can absolutely do that under the terms of the compact. That's a non-qualified license. It's not covered by the compact. Therefore, there is no compact privileges associated with that license. Some states, I think about Pennsylvania, they issue a credential for pre-hospital RNs through their EMS office. Again, state sovereignty allows them to do that. That is not a qualified license under the compact because it's not EMT, paramedic, or a level between. And there are a few more situations of non-qualified license I'll go into. And then finally, it's that concept of that provisional privilege to practice, where I said it's someone who has an otherwise qualified license, but they are in a category where a state EMS office should do additional due diligence. And for transparency and integrity of the compact, we're going to afford states the ability to make that review. So now let's walk through the actual language that we've worked on here. Under qualified EMS license, and so it is basically a EMS license that meets all of the following criteria. Number one, the license is an EMT, paramedic, and I'm slightly paraphrasing, EMT, paramedic, or a level between EMT and paramedic, including intermediates and advanced EMTs. And so that is first requirement. Second requirement, you have to be at least 18 years of age or older. Under state sovereignty, some states choose to issue licenses to individuals under the age of 18. That is a state sovereignty issue. It is not a compact issue. However, under the terms of the compact, you have to be at least 18 with a valid unrestricted license. So if you have someone who is under the age of 18, that would be a non-qualified license. Point number three, for individuals licensed on or before the state when they join the compact, the license is qualified regardless of national registry status. And so again, let me just break that down. When a state joins the EMS Compact, from that day forward, by law, the state requires national registry certification for initial licensure. So from that day forward, it's required. However, in states, there are usually people who joined or became licensed, maybe without national registry, and they've been grandfathered into state licensing process in many cases for decades. The EMS Compact recognizes that, and those people are effectively grandfathered in. But for the day a state joins the compact moving forward, national registry certification is required to be current at the time of initial licensure. Let me phrase this a different way. Under state sovereignty, a state may, in certain circumstances, grant a license based on something other than national registry. Some states will grant a license based on simply reciprocity from another state, meaning that you're a licensed EMT in another state. Therefore, if you come to my state, I'm just going to give you a license based on that reciprocity. The basis for that license is not national registry. The individual may not be current at the time. Some states may grant licenses to certain military transition components that are outside of national registry. Again, state sovereignty issue, that would be a non-qualified license under the compact because it doesn't meet the uniform terms accepted by all states. Next, number four. And this just reinforces that. It phrases it in the same way, but slightly different. And that is clinicians shall have a valid registry at the time of initial certification. Just for clarification, maintenance of national registry is not required, and individuals do not have to have national registry certification to utilize the compact. But at the time of making licensure application to a state, you need to have a valid national registry at that point in time. Number five, in the statute, in the enabling statute, we had a grace period of 5 years that started in 2020 for states to start performing criminal history record checks through the FBI based on fingerprints. And that 5-year grace period expired March 15th, 2025. That's a statutory date that's established by law. And the EMS Compact requires that for any new license issued by a state, that the state performs a FBI compliant biorecord check based on fingerprints. And we recognize that for some situations in a very small number of states, they have not been able to meet this requirement. It's a statutory requirement. So for any license to be considered a qualified license, the individual would have had a fingerprint criminal record check done at the point of the state license being issued. If it was not done, that will be a non-qualified or a provisional license. And then number 6, the license was not issued to an individual with a conviction requiring review. I understand it's the negative in there that makes it confusing, but we're talking about what's a qualified license. So a qualified license is one that does not require a conviction requiring review. In simple terms, if when you apply or an individual applies for a state EMS license, let's assume the individual is fully transparent with full integrity, and they check the box and says, yes, I have a criminal conviction in a category requiring review, then that is an example of something that require review. And that review is based on a combination of state law in the state that's reviewing it, state administrative code, and professional judgment. That's a conviction requiring review. If that's required, that would be a provisional license. Okay. I understand that the concept of a qualified license includes a lot of new information. Let me just pause for a moment before we go into provisional. And Chair Schmieder, is there anything that you'd like to add to that section?
I don't think I have anything to add, Donnie. I thought you did a great job. Any questions from anybody?
Okay, moving forward.
Good.
Provisional privilege to practice. So if someone has a license that is not fully qualified for any of those reasons, and the license is not disqualified, they can apply for, or they will be granted automatically, is how I should say it, a provisional privilege to practice. So the privilege to practice will be intact, but it will have a provisional flag on it. And the provisional flag is someone who would otherwise meet the requirement, but there's something there that would require a review. Under a provisional privilege to practice, the individual will have to contact the state where they wish to practice and request that state to authorize the practice. We will be creating a new technology solution for this that will be rolled out if the rules are adopted, as we anticipate they will be. We'll make this as quick and as painless as possible, but it will be a step required. So, and it will be clearly denoted on the website that it's a provisional privilege to practice. We will not disclose why it's a provisional. It could be for any number of those reasons. And then once a remote state reviews it, it'll be a state-by-state review, and then that authorization will be in effect for as long as the license is active. So you don't have to go back and redo this. But for instance, if I wanted to work in Texas and I had a provisional requirement, I would submit an electronic request to Commissioner Schmieder's office. They would review just as if I was applying for a license. And then if they approve it, then now my provisional license will show that it is recognized in the state of Texas. And it would be recognized indefinitely as long as that license is active and nothing else changes. The next is a simple part at the end. There are still some license categories that are not qualified. And if it's a not qualified license category, there is no provisional privilege to practice. It's just simply not recognized. And this is what I was talking about earlier. and EMR is a non-qualified license. It will never be recognized under the compact because we don't have statutory authority to recognize it. A pre-hospital RN will never be recognized. Likewise, if a state grants a license to something that is outside of traditional EMS or based on some non-standard pathway, the states have agreed upon standards for education and knowledge, skill, and ability. If a state chooses to grant something outside of that, that's a non-qualified license. There is no method to use that under the compact because the statute does not allow it. And then finally, we do have a new provision here I want to highlight, and that is section C2. And that is licenses issued by any member state that is not in compliance with the provisions of the compact that has been sanctioned by the commission. We have a whole section in the rules about preserving the integrity of the compact and the process for sanctioning a state. We've never done this. I hope we never have to do this. But ultimately, the responsibility of this government office is to protect the integrity of the compact as a whole. And for a state to be part of the compact, not only do they have to pass the law, agree to the terms, but they actually have to deliver on the terms. And they have to meet the requirements of the law. Under state sovereignty, if a state, for whatever reason, chooses not to comply with the requirements of the agreement, then that would erode trust in the compact. Under the compact statute and administrative code, there is an escalation process required. So this is not automatic. There's a process that would be required. It would involve notice to the state, notice to the governor, notice to the legislative officials elected in that state. It would be a process of having a plan of correction and a failure of that plan of correction. But ultimately, if we get to an endpoint where a state is not in compliance, then the commission as a whole, through a process, can sanction that state and deem the licenses issued by that state as non-qualified. And if that would be the case, then individuals in that state would no longer enjoy the privileges afforded under the law because their state is not in compliance with the law. So that's a new category in here. And then finally on this section, point D, impact on compact privilege to practice. And we just make it very clear, only individuals with a qualified license may exercise the compact privilege to practice. Individuals with a provisional privilege to practice are not automatically eligible, and they must receive approval from the state which they want to practice in. And then finally, individuals with a non-qualified license are ineligible for compact privilege to practice. I will pause. That concludes section 4.
Donnie, great job on reviewing that. Is there any questions on this? We're trying to make this as clear as possible, so this is your opportunity to ask these questions.
Okay, I'll move to the next section. Section 5. This is a very, very simple cleanup in section 5. If for those on the phone, section 5 is a new section and it has 4 points on it. However, section 5 is aligned with the statute, and we had stakeholder feedback that there was a question if section 5, where it deals with privilege to practices and who can practice, and it's that section that basically says if you pick up a patient in one state and transport to a second state, and they're both parts of the compact, that the compact applies. We had a question saying, does that apply to agencies or does that apply to individuals? The EMS compact is a personnel compact. It does not apply to agencies. But to ensure that we were very clear in that, we added this clarification in section 5 of the administrative code here to say that the phrase individual in the statute is referring to individual EMS clinicians, not individual EMS agencies. So Section 5 is just a clarification. We have multiple parts in the state law that make it clear this EMS compact is about individuals, individual clinicians. It does not change or grant new authority to agencies. And so that's Section 5. Any questions on Section 5? Hearing none, we'll move on forward. And so the very next change is coming up here at the bottom of the administrative rule pack. And let me scroll down through it here. And this is in Section 13. Section 13 is about compliance. It's what I was talking about earlier. The part of the rules and the code and the statute that I hope we never have to utilize, but it's important for integrity of the compact and us as a governmental body. So in the context of compliance and dispute, we added that in this section here. If the commission determines that a compact state has defaulted, and that's the stem of this, that is unchanged, the commission may impose any or all of the following remedies. Again, this is code that is not changed, but we added point number 4. Suspension of the privilege to practice for EMS clinicians whose home state license were issued by the defaulting member state. So we just made it clear that if a state is under sanction by the commission for non-compliance and they have not been able to achieve compliance through a technical assistance and review and notification process, but effectively chooses to remain in non-compliance, then the privilege to practice for those individuals can be suspended after due notice. And then we added a point on that to make sure that we're clear and transparent on how this would be enacted. And that is, if the commission suspends the privilege to practice or terminates the membership of a state, the state that was terminated shall promptly notify all EMS clinicians licensed by the state of the status change and the suspension and termination of that privilege. And then point H, if the commission suspends the privilege to practice or terminates the membership of the compact, all member states shall notify all EMS agencies of the change. We are absolutely committed to the concept of transparency and integrity here at the EMS Compact. And if we encounter a very unfortunate situation where a state is in default, it will be the responsibility of that state to notify every clinician in their state that due to the default, their privilege is no longer recognized under the compact. And then further, we don't want anyone surprised if this would ever happen. And again, I hope this never happens. But all states would send out a mass notification to their entire workforce and their EMS agencies that XYZ state is no longer part of the compact, and anyone practicing under that is no longer eligible to practice under the terms of the compact. And that concludes the changes that we have in the rulemaking process package here. Again, if I summarize this, the EMS Compact has learned over the past 10 years some key lessons. The purpose of this rulemaking package is to preserve the delicate balance between state sovereignty and state rights and uniformity of the compact. We want to ensure that under the EMS Compact, an immediate privilege to practice is recognized, and when it is recognized, it can be trusted and validated. And we want to make sure that agencies have full confidence that they can leverage this law to meet their staffing needs. We want to make sure that individual EMS clinicians have full confidence that when they leverage the privilege to practice, it will be recognized. However, we also want to make sure that we are not creating a backdoor for someone that would not be qualified to obtain a license in a state to come in through a back door and practice in a state they would otherwise not be qualified in. And we believe that this cleans that up. The final thing I would note is that while it's not part of the rulemaking package, this process will work very closely for states that require agency rosters. Not all states do, but if you're in a state that requires an agency roster, then again, this adds even more transparency on the individuals on that roster are fully qualified to operate and practice in that state. With that, Mr. Chair, I turn it back over to you for any questions.
Thank you, Donnie. Thank you for a great overview. I see we have, 21 people on this call. Is there any questions, comments? I'm going to assume silence means you support this, but I would be interested in hearing any kind of feedback. Is this like a bylaw or a nomination? I got to repeat it 3 times? No. But while you're thinking about it, see if you want to say anything, it will be a friendly reminder for the commissioners that are on the call. We have elections in November. Nominations are still open for secretary and vice chair. If you want to nominate yourself or somebody else, you can do that. You should have received an email from that concerning on the process, but